I never imagined that living in a planned community in suburban Charlotte, North Carolina, would turn into a legal nightmare that nearly destroyed my wife's career and our financial stability. But that's exactly what happened when our HOA president decided to wage a personal vendetta disguised as official business. My name is Marcus Webb, and my wife Sarah and I bought our dream home in the Meadowbrook Estates development back in 2023. It was a beautiful 3-bedroom colonial with a pristine lawn, and we were thrilled to finally have a place to call our own after years of apartment living. Sarah worked as a senior financial analyst at Piedmont Trust Bank, one of the largest regional banks in the Southeast, and I ran a small consulting business from home. We thought we had found the perfect setup. The trouble started innocently enough. We wanted to install a small fence around our backyard, so our golden retriever, Bailey, could run around safely without us worrying about her wandering into the street. According to the HOA guidelines, we needed approval for any exterior modifications, so I submitted the proper application form with detailed plans, measurements, and even paint swatches showing that the fence would match our home's exterior perfectly. 3 weeks went by without a response. I called the HOA management office twice, leaving messages both times. Finally, I received a tersely worded email from Patricia Hutchins, the HOA president, stating that my application was denied because the fence violated the aesthetic harmony of the neighborhood. There was no further explanation, no suggestions for modifications, nothing. Just a flat rejection. I was frustrated but figured I would attend the next HOA meeting to plead my case in person. That meeting, held on a humid Tuesday evening in June 2024 at the community center, was my first real encounter with Patricia. She was a woman in her late 50s with severely cut blonde hair that she wore in a helmet-like style, sharp features, and an expression that suggested she smelled something unpleasant whenever she looked at anyone. She wore a crisp white blazer and carried a leather-bound notebook that she consulted constantly, as if it contained the secrets of the universe. When I raised my hand during the open forum portion of the meeting, Patricia's eyes narrowed. I explained our situation politely, noting that several other homes in the neighborhood had similar fences and that we had followed all the proper procedures. I even brought photos of those other fences to demonstrate that our proposed design was consistent with existing structures. Patricia listened with her arms crossed, her lips pressed into a thin line. When I finished, she barely glanced at the photos. "Mr. Webb, those other fences were grandfathered in before the current design standards were implemented. Your application is denied. Next topic." I tried to interject, pointing out that one of the fences in my photos was only 2 years old, but Patricia simply spoke over me, raising her voice. "The decision is final. If you persist in this matter, you will be in violation of HOA regulations and subject to fines. Next topic, please." The dismissiveness stung, but I figured we could work something out eventually. Maybe if I revised the plans or tried a different approach, we could reach a compromise. What I didn't realize was that Patricia had taken my challenge to her authority personally, and she was not the type of woman to let such things go. 2 weeks later, Sarah came home from work looking pale and shaken. I was in my home office wrapping up a client call when I heard the front door slam. That was unusual. Sarah was normally calm and measured, the kind of person who never raised her voice or made dramatic entrances. "Marcus, we need to talk," she said, standing in the doorway of my office. Her hands were trembling slightly, and I could see she had been crying. I immediately ended my call and went to her. "What happened? Are you okay?" She sat down heavily on the couch in our living room, and I sat beside her. "Something happened at work today, something really bad." She took a shaky breath. "My boss, Deanne, called me into her office this afternoon. She closed the door and told me that she had received a very disturbing phone call from someone claiming to be an official with our HOA. My stomach dropped. What kind of phone call? According to Deanne, this person, a woman, identified herself as Patricia Hutchins, the president of our homeowners association. She told Deanne that I was currently under investigation for embezzlement and financial fraud related to HOA funds. Sarah's voice cracked. She said that the HOA was working with law enforcement and that criminal charges were likely to be filed soon. She told Deanne that, as a courtesy, she wanted to inform my employer so that the bank could protect itself from potential liability. I felt like I had been punched in the gut. That's insane. You have nothing to do with the HOA finances. You're not even on the board. This is completely made up. I know that, and Deanne knows that too, but Marcus, I work for a bank. A bank. The mere suggestion that an employee is under investigation for embezzlement, even if it's not true, is incredibly serious. Deanne said she believes me, but she had to report the call to HR and the compliance department. They're launching an internal inquiry. An internal inquiry? Into what? There's nothing to investigate. Sarah wiped her eyes. That's not the point. The point is that someone made a formal allegation to my employer. Even if it's completely baseless, the bank has to investigate. It's policy. And until the investigation is complete, I've been placed on administrative leave. They suspended you. It's not technically a suspension. It's paid leave while they look into the matter. But Marcus, everyone at work is going to know. People talk. My reputation is going to be destroyed. She broke down crying, and I held her tightly, my mind racing. This was Patricia's revenge. It had to be. I had challenged her at the HOA meeting, and now she was retaliating by attacking Sarah's career. But this went beyond petty neighborhood politics. This was slander, defamation, maybe even criminal harassment. You couldn't just call someone's employer and make up lies about them being under criminal investigation. After Sarah calmed down a bit, I helped her draft a detailed timeline of events and a statement explaining that she had no involvement with HOA finances and that the allegation was completely false. Then I did something I probably should have done weeks earlier. I called a lawyer. The next morning, I had a consultation with Robert Brennan, a partner at a local law firm that specialized in civil litigation. Robert was in his early 40s, with graying temples and a no-nonsense demeanor that I found reassuring. I explained the entire situation, from the fence dispute to Patricia's phone call to Sarah's employer. Robert listened carefully, taking notes. When I finished, he leaned back in his chair and steepled his fingers. "Mr. Webb, what you're describing is a textbook case of defamation. This Patricia Hutchins made false statements of fact about your wife to a third party, specifically your wife's employer, that have caused measurable harm to your wife's reputation and career. The fact that she identified herself as an HOA official and claimed to be acting in some official capacity makes this even worse." "Can we sue her?" I asked. "Absolutely. We can file a civil suit for defamation, emotional distress, and potentially tortious interference with your wife's employment relationship. But first, I recommend we send a formal cease and desist letter. Sometimes that's enough to resolve these situations without going to court. However, given the severity of what's happened, I suspect we may end up in litigation regardless." "How much is something like this going to cost?" Robert gave me a sympathetic look. "Civil litigation is expensive. If this goes to trial, you're looking at legal fees in the tens of thousands. However, if we win, we can seek to recover those costs from the defendant. And given the egregious nature of her actions, we might also be able to pursue punitive damages." I swallowed hard. We had some savings, but the thought of spending that money on a lawsuit was daunting. Still, what choice did we have? Sarah's career was on the line, and we couldn't just let Patricia get away with this. "Let's do it," I said. "Send the letter." Robert drafted a strongly worded cease and desist letter that laid out exactly what Patricia had done, explained why her actions constituted defamation and interference with Sarah's employment, and demanded that she immediately retract her statements and issue a written apology. The letter also warned that if she failed to comply, we would pursue legal action seeking substantial damages. The letter was sent via certified mail to Patricia's home address, which I found through the HOA directory. We also sent a copy to the HOA's registered agent and to the property management company that handled administrative duties for Meadowbrook Estates. While we waited for a response, Sarah's situation at work grew more complicated. The bank's HR department interviewed her twice, asking detailed questions about our finances, our involvement with the HOA, and whether there was any truth whatsoever to the allegation. Sarah answered everything honestly and provided bank statements, tax returns, and other documents proving that we had no access to HOA funds and no involvement with the HOA's financial operations. The compliance officer assigned to the case, a stern woman named Margaret Cho, seemed skeptical of the whole thing from the start. During her interview with Sarah, which I was not allowed to attend, she apparently asked pointed questions about why someone would make such a serious allegation if it weren't true. Sarah explained the fence dispute and her theory that this was retaliation, but Margaret seemed unconvinced. She kept saying that people don't usually make up criminal allegations out of nowhere, Sarah told me after the interview. She seemed to think there must be some kernel of truth to it, or at least some misunderstanding that could explain where the allegation came from. "That's ridiculous," I said. "Patricia made it up to hurt you. There's no misunderstanding." "I know, but try telling that to the bank. They're treating this like a legitimate concern that needs to be thoroughly investigated." Days turned into weeks. Sarah remained on paid leave, which meant she was getting her salary but couldn't work. For someone like Sarah, who took pride in her career and her contributions to her team, this forced idleness was torture. She spent her days anxiously checking her email and jumping every time her phone rang, hoping for news that the investigation was complete. Meanwhile, we received Patricia's response to our cease and desist letter. Or rather, we received a response from her attorney, a lawyer named Donald Grayson, whose letterhead indicated he practiced in nearby Concord. The response was infuriating. Grayson's letter claimed that Patricia had acted in her official capacity as HOA president and had a duty to report suspected financial irregularities. The letter alleged, without any supporting evidence, that concerns had been raised about possible misuse of HOA funds, and that Patricia had merely followed proper procedure by notifying relevant parties, including the spouse's employer. The letter further stated that Patricia had not defamed anyone because she had simply reported an ongoing investigation and had not made any definitive accusations of wrongdoing. "This is gaslighting," I said to Robert when we met to discuss the response. "She's trying to claim that there actually was an investigation. There wasn't." I checked with the HOA's treasurer and the property management company. No investigation exists. She made the whole thing up. "Did you get that in writing?" Robert asked. "Yes." The treasurer, a guy named Phil Davidson, was horrified when I told him what Patricia had said. He sent me an email confirming that there has never been any investigation into missing funds, no irregularities in the HOA accounts, and no reason to suspect any kind of embezzlement. He also said that Patricia never mentioned anything about this to the board. Robert nodded, looking pleased. "That's excellent. That email is going to be key evidence." It directly contradicts Patricia's claim that she was reporting a legitimate investigation. So what do we do now? Now we file suit. Based on this response, it's clear that Patricia has no intention of retracting her statements or apologizing. We need to take this to court. Over the next few weeks, Robert and his team prepared our complaint. The lawsuit named Patricia Hutchins as the defendant and alleged defamation per se, intentional interference with employment relationship, and intentional infliction of emotional distress. We demanded compensatory damages for Sarah's lost opportunities and emotional suffering, punitive damages to punish Patricia's malicious conduct, and attorney's fees. The complaint was filed in Mecklenburg County Superior Court in early August 2024. According to North Carolina civil procedure rules, Patricia had 30 days to respond after being served with the lawsuit. Around the same time, Sarah finally received word from her bank. The internal investigation had concluded, and the findings were exactly what we expected. There was no evidence of any financial wrongdoing, no embezzlement, no misuse of funds, nothing. The investigators' report stated clearly that the allegation appeared to be entirely without merit and possibly motivated by personal animus, unrelated to the employee's job performance. Sarah was cleared to return to work, which should have been a relief, and it was to some extent, but the damage had already been done. During her time on leave, her team had been reorganized and her responsibilities had been reassigned to other analysts. When she returned, she found herself sidelined on less important projects. Her boss, Deanne, was supportive but also seemed wary, as if worried that any further controversy might reflect poorly on the department. "I feel like I'm being punished even though I didn't do anything wrong," Sarah confided one evening as we sat on our back porch. "People look at me differently now. I can tell they're wondering if there's more to the story than what's in the official report." "That's exactly why we're suing Patricia," I said. "She needs to be held accountable for what she did to you." In late September, Patricia filed her answer to our complaint. As expected, she denied all allegations and asserted several defenses. Her answer claimed qualified privilege, arguing that as an HOA official, she had a duty to report suspected wrongdoing, and that her statements were protected from defamation claims as long as they were made in good faith. She also claimed truth as a defense, alleging that there had been an investigation and that her statements were accurate. The discovery phase of litigation began in October. This was the process where both sides could request documents, ask written questions called interrogatories, and take depositions. Robert sent Patricia extensive discovery requests, demanding all documents related to the alleged investigation, all communications between Patricia and Sarah's employer, all HOA board meeting minutes, and more. Patricia's responses, when they finally came, were revealing. She produced no documents related to any investigation because, as we suspected, no such investigation existed. She claimed that the investigation had been informal and that no written records had been created. When pressed in her deposition about the specific basis for her concerns about embezzlement, her answers were vague and contradictory. Patricia's deposition took place in Robert's conference room on a cold November morning. I wasn't allowed in the room, but Sarah and I waited in the lobby, anxious to hear how it went. After nearly 4 hours, Robert emerged looking satisfied. "That went very well for us," he said. Patricia's story fell apart under questioning. She couldn't identify any specific facts that led her to believe there was embezzlement. She couldn't name any witnesses or produce any documents. When I asked her directly why she called Sarah's employer, she claimed it was her duty as HOA president to protect the association, but she couldn't explain why calling the employer of someone who wasn't even on the HOA board would protect the association. "Did she admit that she made it up?" Sarah asked. Not in so many words, but the implication was clear. "At one point, I asked her if she was aware that the HOA treasurer had confirmed there was no investigation and no missing funds. She got very flustered and said that the treasurer wasn't aware of all the concerns that had been brought to her attention. When I asked her to identify those concerns specifically, she said she couldn't recall the details. "So she's lying," I said, "almost certainly." But more importantly, her testimony demonstrates that she acted with actual malice. In defamation cases, actual malice means making a statement with knowledge that it's false, or with reckless disregard for whether it's true or false. Patricia's inability to provide any factual basis for her allegation, combined with her admission that she never verified the information before contacting Sarah's employer, shows reckless disregard at minimum. The case slowly ground forward through the winter months. We also deposed Deanne Mercer, Sarah's boss, who testified about the phone call from Patricia. Deanne's testimony was damning. She recalled Patricia stating definitively that Sarah was under active investigation for embezzlement, and that criminal charges were expected. Patricia had also allegedly told Deanne that the HOA had evidence of financial irregularities, and that law enforcement had been notified. None of these statements were true, and Patricia's own deposition had made it clear that she had no basis for making them. Robert filed a motion for summary judgment, arguing that the undisputed facts showed Patricia was liable for defamation as a matter of law, and that the case should be decided in our favor without going to trial. The hearing on the motion took place in February 2025. The judge, a thoughtful woman named Sandra Torres, listened to arguments from both sides. Patricia's attorney argued that there were disputed questions of fact that required a jury trial, but Judge Torres seemed skeptical. "Counsel, your client has admitted that she had no documentary evidence of any investigation, no witness statements, and no specific facts supporting her allegation," Judge Torres said. "She called the plaintiff's employer and made specific factual statements that appear to be false. How is that not defamation?" Grayson, Patricia's attorney, tried to argue that Patricia had acted in good faith based on concerns that had been brought to her attention, but he couldn't identify what those concerns were or who had raised them. Judge Torres pressed him on this point several times, and each time his answers were vague and unsatisfying. In the end, Judge Torres took the matter under advisement, saying she would issue a written ruling within 30 days. Robert felt cautiously optimistic. "She's going to grant summary judgment on liability," he predicted. "The question is whether she'll also decide the damages issue or send that to a jury." Robert was right. 3 weeks later, we received Judge Torres's order. She granted our motion for summary judgment on the defamation claim, finding that Patricia's statements were false, that she had made them with actual malice, and that they had caused harm to Sarah's reputation and career. The judge scheduled a hearing on damages for April. The damages hearing was essentially a mini-trial focused solely on how much money Patricia should pay. We presented evidence of Sarah's emotional distress, including testimony from Sarah's therapist about the anxiety and depression Sarah had experienced during the ordeal. We also presented evidence of lost career opportunities. While Sarah had returned to work, she had been passed over for a promotion that she almost certainly would have received if not for the scandal. The promotion would have meant an additional $20,000 per year in salary. We also sought punitive damages. In North Carolina, punitive damages are available when the defendant's conduct is particularly egregious or malicious. Robert argued that Patricia's actions met this standard. She had deliberately fabricated a serious criminal allegation and weaponized it against Sarah to retaliate for a petty dispute over a fence. This wasn't a momentary lapse in judgment or a misunderstanding. It was a calculated attack designed to destroy Sarah's career. Patricia's attorney tried to paint her as a dedicated volunteer who had made an honest mistake, but this narrative was undermined by the evidence. The HOA treasurer testified that Patricia had never mentioned any concerns about missing funds to him or to the board. Several neighbors testified that Patricia had a reputation for being vindictive and controlling, and that she had retaliated against other homeowners who had crossed her. One particularly memorable witness was Linda Garrett, a woman who lived 3 houses down from us. Linda testified that she had gotten into a dispute with Patricia over holiday decorations 2 years earlier. Patricia had claimed that Linda's decorations violated HOA rules, even though similar decorations were visible throughout the neighborhood. When Linda pushed back, Patricia began filing frivolous violation notices against her for things like garbage cans being visible from the street for more than 24 hours after trash pickup. Linda eventually filed a harassment complaint with the property management company, and Patricia backed off. She uses her position as HOA president like a weapon, Linda testified. If you challenge her or question her authority, she will find a way to make your life miserable. I'm not surprised at all by what she did to Sarah. That's completely consistent with how she operates. The damages hearing lasted 2 full days. At the end, Judge Torres again took the matter under advisement. The waiting was excruciating. We had been living with this lawsuit for nearly a year, and the stress was taking a toll on both of us. Sarah was still dealing with the aftermath at work, and our savings had been depleted by legal fees, even though Robert had worked with us on a payment plan. Finally, in late May 2025, we received the judge's decision. I remember the day clearly because it was a Friday afternoon, and Robert called me directly rather than sending an email, which I took as a good sign. "Marcus, I'm calling with excellent news," he said, and I could hear the smile in his voice. Judge Torres issued her ruling on damages, and it's a complete victory. She awarded Sarah $200,000 in compensatory damages and $90,000 in punitive damages. She also ordered Patricia to pay your attorney's fees, which amount to approximately $43,000. The total judgment is $333,000. I was stunned. I had hoped we would win, but I hadn't expected such a substantial award. $300,000, are you serious? Completely serious. The judge was clearly disturbed by Patricia's conduct. In her written order, she called Patricia's actions malicious, calculated, and utterly without justification. She noted that Patricia had shown no remorse and had continued to defend her actions even after it became clear that her allegations were false. The judge felt that a substantial punitive award was necessary to deter this kind of behavior. When Sarah got home from work that evening, I met her at the door with a bottle of champagne. "We won," I said simply. She burst into tears and we held each other for a long time. The relief was overwhelming. After months of stress and uncertainty, we finally had vindication. A judge had looked at the evidence and concluded that Patricia was wrong, that Sarah had done nothing wrong, and that Patricia needed to pay for what she had done. But of course, winning a judgment and actually collecting the money are 2 different things. Patricia's attorney filed a notice of appeal, which meant the case would go to the North Carolina Court of Appeals. This was frustrating but not unexpected. Robert warned us that appeals could take a year or more to resolve. In the meantime, we learned that the HOA board had finally taken action against Patricia. Several board members, including Phil Davidson, the treasurer, had been horrified when they learned about the lawsuit and Patricia's conduct. There was apparently a heated board meeting in June, where several members called for Patricia's resignation. She refused, claiming that she had done nothing wrong and that the lawsuit was a vindictive attack by disgruntled homeowners. The board didn't have the power to unilaterally remove Patricia from her position, but they did have the power to call a special meeting of the full HOA membership to vote on her removal. Such a meeting was scheduled for July. Under the HOA's bylaws, removal of an officer required a 2/3 vote of the membership. Sarah and I attended that meeting, along with what appeared to be nearly every homeowner in Meadowbrook Estates. The community center was packed, and the tension in the room was palpable. Patricia sat at the front table with her arms crossed, her face set in a defiant scowl. Phil Davidson, acting as the meeting chair, explained the situation to the assembled homeowners. He carefully detailed the lawsuit, the judge's findings, and the judgment that had been entered against Patricia. He also explained that the HOA's insurance policy likely would not cover the judgment because Patricia had been acting outside the scope of her official duties when she made the defamatory statements. "What this means," Phil said, "is that Miss Hutchins is personally liable for over $300,000. It also means that her continued presence as HOA president exposes the association to potential liability if her actions are seen as representing the HOA. For these reasons, the board is recommending that the membership vote to remove Ms. Hutchins from her position as president and from the board of directors." Patricia was given an opportunity to speak in her defense. She stood up, her face flushed, and launched into a rambling speech about how she had dedicated years of her life to the HOA, how she had always acted in the best interests of the community, and how she was being persecuted for trying to protect the association's finances. She never once acknowledged that her allegations against Sarah had been false, and she never apologized. When she sat down, several homeowners raised their hands to speak. One after another, people stood up and shared their own stories of Patricia's vindictive behavior. It became clear that Sarah and I were not her only victims. She had spent years using her position to bully and harass people who disagreed with her. The vote was called, and it wasn't even close. Out of 187 homeowners present or represented by proxy, 162 voted to remove Patricia from office. She was out. Patricia stood up abruptly, knocking her chair over in the process. "You're all going to regret this," she said loudly. "This community is going to fall apart without my leadership, and you'll have no one to blame but yourselves." She stormed out of the meeting, and we never saw her at another HOA event again. The appeal process dragged on through the rest of 2025 and into early 2026. Patricia's appellate attorney argued that the trial court had erred in granting summary judgment, and that the damages award was excessive. Our appellate attorney, working under Robert's supervision, filed a detailed brief defending the judgment and arguing that Patricia had forfeited her right to complain about the amount of damages by engaging in such egregious conduct. The Court of Appeals heard oral arguments in January 2026. Robert attended the hearing and reported back that the three-judge panel seemed skeptical of Patricia's arguments. One judge in particular, Judge William Ramsey, had pressed Patricia's attorney hard on the issue of actual malice. "Your client called the plaintiff's employer and stated as fact that the plaintiff was under investigation for embezzlement," Judge Ramsey said during the argument. "But your client had no evidence that any such investigation existed. She couldn't name a single specific fact supporting her allegation. How is that not actual malice?" Patricia's attorney tried to argue that Patricia had subjectively believed that there was an investigation based on unspecified concerns, but this argument seemed to fall flat. The judges appeared unconvinced. The Court of Appeals issued its decision in March 2026, just a few weeks ago. The decision was unanimous. The judgment was affirmed in full. The court's opinion, written by Judge Ramsey, was scathing in its assessment of Patricia's conduct. The defendant's actions represent a particularly egregious abuse of her position as HOA president, the opinion stated. Rather than using her authority to serve the community, she weaponized it to pursue a personal vendetta against a homeowner's spouse, who had no involvement with the HOA's operations. Her false accusation of criminal conduct was not only defamatory, but also endangered the plaintiff's livelihood and reputation. The trial court's substantial damages award was appropriate given the malicious nature of the defendant's actions, and her continued refusal to acknowledge any wrongdoing. The opinion also rejected Patricia's argument that the damages were excessive. The compensatory damages appropriately reflect the serious harm to the plaintiff's career and emotional well-being, the court wrote. The punitive damages, while substantial, are proportionate to the defendant's reprehensible conduct and serve the important purpose of deterring similar misconduct by others in positions of community authority. With the appeal resolved, Patricia was now legally obligated to pay the full judgment amount of $290,000, plus attorney's fees, which had grown to approximately $57,000 with the appeal, for a total of $347,000. We also learned that Patricia had been ordered to pay her own attorney's fees for the trial and appeal, which likely amounted to another $80,000 or more. Patricia's attorney contacted Robert to discuss payment arrangements. It quickly became apparent that Patricia did not have the liquid assets to pay the judgment in full. She owned her home in Meadowbrook Estates, which was valued at around $450,000, but had a mortgage of about $200,000. She had retirement accounts but would face substantial tax penalties if she liquidated them. She also had some savings, but not nearly enough to cover the judgment. Robert filed a motion to compel payment and began the process of enforcing the judgment. This could involve garnishing Patricia's wages, placing liens on her property, or forcing the sale of assets. It was an unpleasant process, but Patricia had left us no choice. 2 weeks ago, Patricia's attorney reached out with a settlement proposal. Patricia would agree to pay us $290,000, the original judgment amount minus attorney's fees, through a structured payment plan. She would make an immediate payment of $50,000 from her savings, followed by monthly payments of $5,000 until the balance was paid off. She would secure the debt with a lien on her home. In exchange, we would agree not to pursue collection of the attorney's fees portion of the judgment, and not to seek garnishment of her wages or forced sale of her property. Sarah and I discussed it at length. On one hand, we wanted Patricia to feel the full weight of the consequences for what she had done. On the other hand, a structured payment plan would give us certainty that we would actually collect the money, whereas forcing a sale of her assets could be time-consuming and expensive, with no guarantee that we would recover the full amount. "I just want this to be over," Sarah said. "I want to move on with our lives and put this nightmare behind us." I agreed. We accepted the settlement proposal. Patricia made the initial $50,000 payment last week, and the payment plan has been formalized in a court order. We will receive $5,000 per month for the next 4 years until the full amount is paid. If Patricia misses a payment, we can immediately pursue all available collection remedies. Yesterday, we received a letter in the mail. It was from Patricia, handwritten on plain white stationery. I almost threw it away without reading it, but Sarah convinced me to at least see what it said. The letter was brief and awkwardly worded, but it appeared to be an apology of sorts. Patricia wrote that she had made mistakes and that she regretted the situation and hoped that we could move forward. She did not explicitly acknowledge that she had lied or apologized for the specific harm she caused, but it was at least a recognition that she had done something wrong. "It's not much of an apology," Sarah said after reading it. No, it's not, I agreed, but it's something, more than she's ever given before. We decided not to respond to the letter. What was there to say? No apology could undo the damage Patricia had caused or give Sarah back the months of anguish and professional setbacks she had endured. But the letter did provide a small sense of closure. This morning, Sarah and I were sitting on our back porch enjoying our coffee when Bailey came running up, tail wagging furiously. She had been exploring the yard, which is now enclosed by a beautiful white picket fence that we had installed last fall. After Patricia was removed as HOA president, the new board reviewed our fence application and approved it immediately. The fence has been up for 5 months now, and Bailey loves having the freedom to run around safely. You know what's funny? Sarah said, scratching Bailey behind the ears. All of this happened because of a fence, a stupid fence. Not just a fence, I corrected. It happened because one person had too much power and no accountability. Patricia thought she could do whatever she wanted and nobody would stop her. Well, we stopped her, Sarah said. Yes, we did. We sat in comfortable silence for a while, watching Bailey chase a butterfly across the yard. The nightmare was finally over. Patricia was facing serious financial consequences for her actions. Sarah's reputation had been vindicated by the courts, and we had our fence. More importantly, the experience had taught us valuable lessons about standing up to bullies, even when it's difficult and expensive. It had also taught us about the importance of community. Many of our neighbors had supported us throughout the ordeal, attending the HOA meeting to vote Patricia out and offering words of encouragement during the darkest days of the lawsuit. The new HOA board, led by Phil Davidson as the interim president, had implemented reforms to prevent future abuses of power. Board members were now required to attend training on their legal obligations and ethical responsibilities. The board had adopted clear procedures for investigations and complaints, including requirements for documentation and due process. And there were new safeguards to ensure that board members couldn't act unilaterally on behalf of the HOA without proper authorization. Last month, Sarah received the promotion she had been passed over for during the investigation. Her new title is Director of Financial Analysis, and it came with a substantial raise. Her boss, Deanne, had been apologetic about the delay and had worked behind the scenes to ensure that Sarah was considered for the next available position. Sarah's reputation at the bank had been fully restored, and she was once again being assigned to high-profile projects. As for me, my consulting business had actually grown during the past year. I had gained several new clients through referrals, and I was busier than ever. The lawsuit had been stressful and expensive, but it hadn't derailed our lives the way Patricia had presumably hoped it would. If anything, we had emerged stronger and more resilient. This afternoon, we are hosting a barbecue for some of our neighbors. Phil Davidson and his wife are coming, as well as Linda Garrett and several other families from the neighborhood. It's a celebration of sorts, a chance to relax and enjoy each other's company without the cloud of the lawsuit hanging over us. As I prep the grill and Sarah arranges chairs on the patio, I find myself reflecting on everything that has happened over the past 2 years. When we bought this house, we never imagined we would end up in a legal battle with our HOA president. We never imagined that a simple fence application would spiral into defamation, threats to Sarah's career, and a nearly $350,000 judgment. But we also never imagined that we would discover such strength in ourselves and such support from our community. We learned that standing up for what's right is worth the cost, even when that cost is high. We learned that bullies can be defeated when good people refuse to be intimidated. And we learned that justice, while sometimes slow and expensive, is real and achievable. Bailey barks excitedly as the first guests arrive, and Sarah welcomes them with warm hugs. The afternoon sun casts a golden glow over our backyard, and the smell of burgers on the grill fills the air. This is what we fought for: the ability to live peacefully in our home, surrounded by good neighbors, without fear of retaliation from petty tyrants. Patricia Hutchins tried to destroy my wife's career over a fence dispute. Instead, she ended up losing her position, her reputation, and nearly $350,000. The lawsuit taught her an expensive lesson about the consequences of abusing power and making false accusations. More importantly, it sent a message to anyone else who might be tempted to use their position in an HOA or other community organization as a weapon against their neighbors. As I flip burgers and chat with Phil about upcoming HOA projects, I catch Sarah's eye across the patio. She smiles at me, a genuine, relaxed smile that I haven't seen in months. That smile tells me everything I need to know. We made the right choice in fighting back. We refused to be victims. And in the end, justice prevailed. The cookout lasts well into the evening, with neighbors sharing stories, kids running around the yard, and Bailey stealing hot dog buns when she thinks no one is looking. It's a perfect spring evening in Charlotte, and for the first time in a long time, everything feels right. Tomorrow, Sarah will go back to work in her new role as Director of Financial Analysis. I'll have client calls and project deadlines to meet. Patricia's $5,000 check will arrive in the mail, the first of many monthly payments that will continue for years. Life will go on as it always does. But tonight, we celebrate. We celebrate victory, justice, and community. We celebrate the fact that ordinary people can stand up to bullies and win. We celebrate the simple pleasure of having friends over for burgers in our fenced backyard, something that should never have been controversial, but became the catalyst for a much larger battle. As the last guests leave and we clean up the patio, Sarah takes my hand. "Thank you," she says quietly. "For what? For believing me, for supporting me through all of this. For being willing to fight even when it seemed impossible." I squeeze her hand. "Always, we're a team, and nobody gets to mess with my team." We stand together in our backyard, Bailey sprawled at our feet, looking up at the stars beginning to appear in the darkening sky. Somewhere out there, Patricia Hutchins is presumably writing another check, one of many she'll write over the next several years to pay for her vindictive actions. We don't take any pleasure in her financial hardship, but we do take satisfaction in knowing that she was held accountable. The Meadowbrook Estates HOA is under new leadership now. Leadership that understands that community service means serving the community, not wielding power over it. The reforms that have been implemented will make it harder for future board members to abuse their positions. And every homeowner in the neighborhood now knows that they have rights, and that those rights can be enforced through the legal system if necessary. This story could have ended very differently. If we had been intimidated into silence, Patricia would have continued her pattern of retaliation and abuse. Sarah's reputation would have remained under a cloud of suspicion. And Patricia would have learned that she could make false accusations without consequences. Instead, we fought back, and the system worked the way it's supposed to work. False statements were proven false. Harm was compensated. A bully was held accountable. As we head inside for the night, I take one last look at our fence, the innocent cause of so much trouble. It's a good fence, solid and attractive, exactly what we wanted from the beginning. Bailey loves it. The neighbors think it looks nice. And every time I look at it, I'll remember what it represents. Not just a boundary for our property, but a line we drew against injustice. The legal battle is over, but its lessons will stay with us forever. Stand up for what's right. Don't let bullies win. Support your community. And when someone tries to destroy you with lies, fight back with truth. The truth may take time to prevail, but prevail it will if you have the courage to pursue it. Tonight, as I fall asleep next to Sarah in our home in Meadowbrook Estates, I feel a deep sense of peace. The nightmare is over. Justice has been served. And tomorrow is a new day, free from the shadow of Patricia Hutchins and her vindictive schemes. We won, not just in court, but in every way that matters. Our reputation is intact, our careers are thriving, our community is stronger, and our fence stands tall in the backyard. A permanent reminder that sometimes the smallest things can trigger the biggest battles, and that those battles are worth fighting if you're fighting for what's right.